I'm going to talk about Section 9 witness statements. So the legislation is Section 9 of the Criminal Justice Act 1967, and that provides for witnesses in criminal proceedings to give written evidence. The wording of a Section 9 statement is this: "This statement is true to the best of my knowledge and belief, and I make it knowing that, if it is tendered in evidence, I shall be liable to prosecution if I have wilfully stated in it anything which I know to be false or do not believe to be true." The rules concerning witness statements are set out at Chapter 16 of the Criminal Procedure Rules, and that sets out the requirements for a witness statement. So it must contain that form of wording, it must have the individual's name and their age if they're under 18. So the statement is usually used by the police or the prosecution, but it can also be used by the defence, and it's possible for the defence to provide witness statements in Section 9 format as well. There are rules about how the statements can be used in court, whether they have to be agreed beforehand, and if they're not agreed, whether the person who makes the statement has to attend court to give evidence. So that's Section 9 witness statements under the Criminal Justice Act 1967. I do want to talk about retraction statements. Now, a retraction statement is frequently used when an individual has made a complaint of some sort. We'll say, for the sake of argument, this is a complaint of assault, an allegation of assault, and subsequently has given a complaint to the police under Section 9 and then wants to retract. So that's a retraction statement. In those circumstances, it is possible for them to provide a statement under Section 9 of the Criminal Justice Act 1967, setting out that they want to retract their earlier statement. So that's possible for that to be done. The other matter I want to talk about in connection with witness statements concerns military personnel who are ordered by their chain of command to give a statement. Now, if that statement is in Section 9 format, then that statement potentially is unlawful, because potentially if the individual has given a statement which incriminates themselves, self-incrimination, then it shouldn't be admitted under Section 9. If they're the subject of investigation, if they're thought to have committed a crime, the correct procedure is not for them to be ordered to give a statement. The correct procedure is for them to be interviewed under caution. Remember, the interview under caution, I provided a video about this previously. The caution is you do not have to say anything, but it may harm your defence if you do not mention, when questioned, anything that you later rely on in court. Anything that you do say may be given in evidence. Once that wording has been given, the evidence provided in the interview under caution is admissible, but it shouldn't be the circumstance under which the chain of command asks a serviceman or orders a serviceman to give a witness statement under Section 9 of the Criminal Justice Act 1967 to give a statement of events that will potentially incriminate themselves. That's not the correct format, and it should be inadmissible. So to recap, the law relating to witness statements is set out at Section 9 of the Criminal Justice Act 1967. There is the form of wording that confirms that the individual makes the statement believing it to be true and knowing that if it is tendered in evidence and it's not true, then they may be liable for prosecution. Retraction statements should be on the Section 9 format, and it should set out in a retraction statement that the individual does not support the prosecution, or if they said anything that was untrue, or if they want to clarify anything, that can be set down in a retraction statement. And for service personnel who have been ordered to give a statement, that should not be in Section 9 format, because if they are suspected of committing an offence, the Section 9 format, they need to be warned that they may be given a statement that incriminates themselves. That's not the correct procedure. The correct procedure, if they're suspected of committing an offence, is for them to be interviewed under caution with the correct caution and the correct legal safeguards.